Every day, citizens around the country are faced with new dilemmas. Dilemmas that affect them profoundly. Whether it's injustice, discrimination, falling through the cracks, scandal and cronyism, balances of power, ethics, religious freedoms, state versus citizens, and unfunded mandates, and the list goes on and on and on. Welcome to Speak Up. It's directed at those who have fallen through the cracks, and it gives them a voice. It's your turn to speak up, to stand up and fight back. Welcome to Speak Up. I'm Kevin Avard, your host, and I have the privilege of introducing a special guest, Mr. Jim Miller. Welcome to the show.
Thank you.
I'm glad that you're here.
Thank you for having me.
One of the reasons I asked you to join me, Mr. Miller, is because I do sit on the Redress of Grievance Committee. And over and over and over again, I hear the buzz, Miller versus Todd, Miller versus Todd. And I wanted to know who this Miller was. And that's why I wanted you to come on the show, to introduce myself to you, the people that know about the case or have heard about it, and put a face to a name. So welcome to the show.
Thank you.
And let's get started. You know, again, we're seeing a lot of issues come before our committee, and they range from filing against the Attorney General, who seem to be aggressive in a case, or family court. And family court seems to be dominating right now. There seems to be an ongoing issue with fathers, especially in our committee, that feel they've been served injustice, to say the least. And wanted to get a little bit of your perspective on that, and maybe a historical perspective. Why are we at this point?
That's a question that just has so many dimensions to it. It's difficult to talk about. But I think what's important is to understand where we're at today. I think you need to step back 100 years and look at where we were back at the turn of the century during the Industrial Revolution. At that time, women weren't allowed into the workplace. That was strictly the domain of the male. Mom was supposed to stay home, take care of the children. She was take care of the house, do the cooking, the cleaning. Right or wrong, that's the way the world worked. All right. The courts, being a reflection of society, then introduced what's called the tender years doctrine, which essentially says that if a child is under the age of, and I've heard different numbers ranging usually 14 and down, that there is a presumption that mom should have custody of the child. She's best able to take care of the child because that was her role in society. That was something that prevailed throughout most of the 1900s. We go into court, mom's going to get the kids. That's just all that it is, and it's understandable. We saw that up in the 60s and 70s. If you take a look at television, which is nothing more than a mirror on our society, why Ward Cleaver went to work, June Cleaver stayed home and took care of Wally and the Beeve. Why Fred and Barney went off to the gravel pit, Betty and Wilma were taking care of Bam Bam and Pebbles. That is the way our society worked. Along comes the women's rights movement that we started to see in the 70s and in the 80s. Women wanted into the workplace. They started migrating into the workplace, and that was great. Men, on the other hand, had to pick up the slack at home. They started having to do the cooking, the cleaning, the shopping.
Shared responsibilities.
Taking care of the children. And all of a sudden, there was an unintended consequence of all of that, something that I don't think anybody really saw coming. Dad was helping Susie get off the bus at night. Dad was feeding Susie. Dad was helping her with her homework and putting her to bed at night, and Dad liked it. So now when we go into court and we are figuring out where is Susie going to live, Dad's saying, wait a minute here. I'm as much of a parent as mom. I want my time. I'm not going to lose my relationship with the child. Again, the judiciary is a reflection of what's going on in society. The law started to change. The idea of the tender years doctrine disappeared, and was replaced with what now we would term the best interest of the child doctrine. And there's a number of factors, various states implement it different ways, but now we're going to look at both parents and try to figure out where's the child best off.
Right. So that seems to be another question that comes before the committee. Many people quote that. What is being done in the best interest of the child? And we all say, well, where's the definition of that? Where do we find the definition of what is the best definition of the child? I believe you actually were responsible for introducing some legislation or giving some legislators an idea. I don't know, was it 591?
415,
415
and 506, and there is a couple more bills that I've been working on with legislators to try and get passed.
And what is the gist of, say, the one was on the equal parenting, I believe. Is that correct?
No, I didn't do equal parenting.
Okay, I think maybe that Jeff Lignia was fighting on that particular one. But there was one about sealed envelopes, I remember, and that was 415.
I think you're looking at 415.
Right.
The way 415 was structured, and I guess before we talked about that, we kind of have to back up.
Mm-hmm.
DCYF, when an accusation has been made that a child has been abused, DCYF comes in and they do an investigation.
Right.
Okay. Those records are available to the parents, but only if DCYF says so. Okay, they have the right to deny. Frequently, they do, or they deny parts of the record in my particular case. 415 was drafted to prevent that from happening. 415 essentially said if during the proceedings of a child custody case, if one of the parents has their rights with the child restricted or prohibited, in other words, can't see the child or can only see the child in supervised setting, then that parent had the right to get all of the records that DCYF has, regardless of the media upon which to record it, regardless of who created it. And that's been a big hiding spot. DCYF will say, well, we didn't create the record, so we have no duty to turn it over. 415 remedied that, right, and said that if you have the record in your possession, you will turn it over. And that's where that's going. Because as the father who's had my rights with a child terminated, or not terminated, but suspended. I couldn't see my children, I couldn't talk to my children, I couldn't have any contact with them whatsoever. I had no idea what was going on behind the scenes. That, I thought, was a major injustice, because if you stop to think about it, your right to raise your child, that's what they call a fundamental liberty interest. And these fundamental liberty interests are the very fabric of our society. Right. Once you start to interfere with them, things just don't work. Your relationship with your children fails, your relationship at work, because there's a presumption that maybe something really happened. And meanwhile, DCYF is sitting on this information that may be able to you might be able to use to get your children back and clear up this cloud of suspicion.
Which begs a question. If that cloud of suspicion can be produced to exonerate, why aren't they doing that?
That's a question for somebody smarter than I. I really don't know the answer, why they feel that they're empowered to hide this information.
Right. My other question, though, I want to just bank on that. I don't know, and you don't know.
No.
The other question is, if there's substantial evidence that is put in a sealed envelope that is held from both parties, and that evidence is so bad that the child is taken away from one individual, meaning the father or the mother, why doesn't the court further go and say, look, we've got evidence against you that something bad's happened here, and that's why we've taken away your child, and we're punishing you, we're taking your liberty away from you to see that child. In addition, you should be prosecuted based upon that evidence. Am I missing something? I'm talking layman's terms. If there's something in there that you've done bad, shouldn't that come out so that you could say, look,
well, from a legal, I have a right to face my accusers, right, and I have a right to know what information is being held or being used against me. And I think here, although I really didn't want to address my case particularly, but I think it's very much on point here. In my particular case, I was accused of abusing my children. Okay. Shortly after the accusations were made, the children were taken away. Shortly after they were taken away, DCYF, in conjunction with the Child Advocacy Center, interviewed my children, and my children denied anything happened. But yet, I still didn't get to see my children. The investigation was determined to be, the accusations were determined to be unfounded. The investigation was closed. As soon as that investigation was closed, remember, I still haven't seen my children, another investigation started. Another accusation was made. This time, the prohibition from having contact with my children continued, and they interviewed my children again on videotape. This time, the children had things to say. When the children were asked whether or not it really happened, the children denied that it happened. When the children were asked, why are you saying this? You know, did Daddy tell you to say it? And the answer was, no, Daddy didn't tell me to say it. I don't see my daddy. And when they asked again, well, who might have told you to say this? The child was very specific on who told them to say these things.
They were coached.
They were coached. The investigation ended unfounded. Okay.
And so we have that information, though, that on tape. In one other instance, it was in a sealed envelope, or do we call it a sealed envelope? Or?
I don't know if sealed's the proper word, because we had no knowledge of these tapes. Sealed seems to imply that you know there's something there, but you don't know what it is. We weren't even told that those videotapes existed.
So doesn't that violate some type of liberty, too? I'm not laughing. I'm incredulous over the lack of transparency and accountability for some of these agencies that are actually taking away your children, and you have seemingly no recourse.
And you don't. You really don't, because in my particular case, this scenario that I described, it happened repeatedly. Okay, there was 3 instances that I can think of off the top of my head. And every single time the child denied that Daddy did anything, and the child identified the person who was coaching him to say these things. And those videotapes were kept away from me. All the while, for the 2.5 years, I didn't see my children. I had no contact with them. And maybe this brings it into context a little bit. When this started to happen, my children were 2 and 3. Okay, they had trouble following simple instructions, but yet they were able to describe graphic acts, which just was wrong. That doesn't fit together.
Correct.
DCYF has this information that would exculpate me, which would exonerate me, and yet they hid that from us. Matter of fact, it was worse than hiding it from it. When we found out about it and we made demands for it, they refused to turn it over. All the while, this agency, who's supposedly charged with the best interest of the children, making sure children are protected, they had this information, and yet they kept it from us. Why? I have no idea.
Well, we'll get into that probably in another segment, maybe.
I hope.
Getting back to a little bit more on the history of the courts, if you don't mind me going there a little bit. In 1978, the Supreme Court was granted by the legislature the administrative rulemaking ability. And apparently, what wasn't on the ballot was the fact that these administrative rules, so promulgated, shall have the effect of law. That last little line was not on the ballot. We've definitely proved that in committee, actually. And since 1978, there seems to be a pattern where some of these rules turn into a cancer for people's rights. And I'd like to bring up Rule 1.2.
Right.
Rule 1.2, waiver of rules in the interest of justice. And I believe I'm quoting that correctly.
Something like that.
Something
sure.
like that. And originally, I haven't talked with you a little bit about this, the intent of that rule started off really good.
I can't talk about New Hampshire, but I can talk general-wide. I can talk about Michigan, New York, and I can talk at federal level. Rule 1.2, with this waiver of rules, is to prevent the manifest injustice from taking place. Okay. I'm trying to think of an example here. You have a filing date. It has to be in by 4 p.m. on a certain date, and the attorney running to the courthouse gets in a car accident or something. Something happens that he can't make it.
Right.
That would be a manifest injustice to the client, because something happened on the way to the courthouse. The court has the right to say, we're going to waive that rule. We're going to allow the attorney to have the extra day to get it filed.
In the interest of justice.
In the interest of justice. You don't want to use the rules as a weapon. You want to use the rules to make sure that justice takes place in the courthouse.
Right. So I'm thinking about the Johnson case was recently founded, and he actually had an issue with sealed envelopes and information that could exonerate him, according to him. But our committee subpoenaed whatever is in that envelope. We still don't know yet. But he quoted the courts on the issue of Rule 1.2, where, blame it on the legislature. They gave us this right to waive rules of evidence. Well, no, they didn't. Not really. Did we give them that right?
I don't think, and I haven't read your Rule 1.2. When I say yours, I mean New Hampshire's Rule 1.2. But I believe it refers to the court rules, not the rules of evidence.
Right.
Okay, so.
That being the case, if they waive rules of evidence, doesn't that break some type of statute?
What you're talking about here is, I believe, Rule 1110 of the rules of evidence, which say the rules of evidence don't apply in marital cases. Okay, that's really an interesting concept. Hearsay may or may not be allowed in. Traditionally, you don't allow hearsay in because it's unreliable. Affidavits may or may not be allowed in. The interesting point about this is what the guardian says is all hearsay. Essentially, she's a walking, talking, and breathing affidavit.
Which is a very, very interesting topic, seeing how that the Supreme Court in New Hampshire, just ruled on the quasi-immunity that some of these guardian ad litems have, and leaving them totally unaccountable for any of their actions, apparently. So if they misrepresent the case, you can't go back and sue them.
No.
Because they're considered a part of the court.
Essentially, they're an arm of the court.
In the Johnson case, and I just keep pulling him out of the hat because he was one of the more recent ones, the problems that he had with the guardian ad litem were because of the guardian ad litem was using hearsay. And his case was based upon hearsay. And he hasn't seen his child in 2.5 years. He has committed no crime. I don't get it. Your children are taken away from you. You've committed no crime. You are not adjudicated as an unfit parent, but whatever this person says is a God, because you can't challenge it. It's put in a sealed envelope.
You can challenge it in the sense that you have right to see their records. But what the court seals, you're right, you can't see that. And you have no idea what's in those records.
Well, just to bank on that statement alone, in the Vandenberg case, and I believe in the Youssef case, there was a line which says that you agree, when you sign that document with the guardian ad litem, you have no rights to that information.
Okay.
That blows my mind. I believe it was in the Youssef case where he actually pointed that out in committee. And the problem was, he signed it. So it was a document that he agreed to. It was a contract. But that document was under duress because the court said, look, you're not going to see your children unless you sign this document.
Sign it or don't see your children. Right.
And basically you're signing your rights away to see your child.
Yes.
I don't know how we got to this point in our court system. Going back to, mother knows best at all times, and she's always going to be the fit parent, and you're guilty until proven innocent? Is that how this works?
Although politically incorrect, yeah, that is how pretty much the system works. And I think we've got to go back to touch DCYF. Understand, they're the police or the judge, the jury, and they're the executioner. The day they walk in your house and they take your children, which they have the right to do, you have a tremendous uphill battle. But your fundamental right to raise your child has just been tremendously abridged. And now you've got to go to court and try and get them back. It's really hard to get the horse back in the burning barn sometimes. I'm not sure exactly what the answer is, because you do have to protect the rights of the children, but not ignoring the rights of the parent. What's the answer here? I'm not really sure. I'm not really sure. Greater safeguards, perhaps that I know frequently when the children are taken away, you certainly can go into court and petition to get your children back right away. But all too frequently, in my particular case, I've heard it in other cases, they have what they call an offer of proof hearing. The attorneys stand up and say, if my client was going to testify, he would tell you this. Or if my client was going to testify, they would tell you that. Okay, that's what you hear. There seems to be, we want to hurry up and get this off our docket. We want to move this hearing over so we can get to the next hearing behind it. And that's an interference in my right to raise my children. There should be a full evidentiary hearing if you're going to take my children away. Not a 10-minute offer of proof hearing. But I want to be able to call witnesses. I want to be able to examine my witnesses. I want to be able to cross-examine their witnesses. I want to try and put an end to this before it gets too far. Take the focus away from the parent, though, who's had his child taken away. He's a big person. He'll get over it. Maybe he will, maybe he won't. But think about the child who just lost a parent for no reason whatsoever. My children lost their dad for 2.5 years. They were children, little babies, when they were taken away. When I saw them again, I didn't recognize either one of them. That's a travesty.
And
Okay.
you had no influence, and just to tell you a personal story, when I was young, my mom got all 5 of us, and come to find out she was the abuser. This is in Washington State. My dad was railroaded, completely railroaded, and accused in the whole 9 yards, and we ended up in foster care, the whole 9 yards, and the courts were reluctant to give all 5 of us to my father. Eventually, after broken arms, burnt hands, and a bunch of other things, the court said, Mr. Avard, we apologize. Here's your children. And he fled the state, and he came to New Hampshire, where eventually we ended up in an orphanage. I can remember, as a 3-year-old child, I'm almost 50, I can still remember my first day. I can remember going into that orphanage and saying goodbye to my dad. And I can remember the long-lasting hurt that was. And every week when my dad would visit us, the pain in my heart and the waiting to see my dad, only because he was ruined. He was financially devastated. And, of course, going through the whole divorce process. That man was a good man. And he eventually took us out of the orphanage, and he raised 5 of us to the best he could without support of the state, without support, child support, and without any help other than maybe from some family members. And I brought that up to say this, is that your point, that it's not just the parents that are hurt. The children are hurt. They're devastated. They want daddy. They want mommy. Now, the divorce in itself is a difficult issue. It's a difficult problem for everybody. But for the courts to come in and say, look, you're guilty and you don't belong with your child because there's a suspicion over you that you're not going to be able to prove because we have this evidence put in a sealed envelope, totally hurts the child.
Absolutely. It's the child who's the true loser here. Understand that frequently those actions happen based on nothing more than an accusation, a self-serving accusation. And over time, those accusations kind of fall apart. We realize that they weren't true. Dad gets reunited with the children, or mom gets reunited with the children. The children try to rebuild a bond with that parent. But you can't undo the entire damage that was done. I see this in my own daughters on a daily basis when I'm with them. It's not the way it was before they were taken away. We constantly have problems with it. They're constantly afraid Daddy's going to disappear again. They haven't forgotten that. And that's something that's going to haunt them their entire lives. Because I did something wrong? No, because we had a knee-jerk reaction out of a court that was more concerned about getting the children away from Dad and then keeping them away while the process takes place, this amorphous process takes place. As a father, you're constantly defending, and I was constantly defending. And we've all heard the old adage, where there's smoke, there's fire. That's true here, or at least that's the thought here. I found in my own case that once the accusations were made, people started coming out of the woodwork. We're going to help you, Mom. We'll make another accusation. We're going to help you, Mom. We're going to make another accusation. People believed, hey, the court took the kids away. Well, courts don't do that lightly, right? So he must have done something. And in fact, no. They were just accusations that were made to try and get leverage in a child custody case.
And on that case, we're going to be back with another guest on another segment. And I want to thank you for joining us on the show. Stay tuned for our next segment. And welcome back to Speak Up. I'm joined with another guest here, Mr. Josh Youssef, a Senate candidate. Welcome to the show.
Thank you, Kevin.
You've been on before, and
Yes,
we want to welcome you
back.
back. And of course, Mr. Jim Miller of the infamous Miller versus Todd. Thank you again for joining us for another segment.
Glad to do it.
Great. Well, I wanted to continue our conversation that we were having, and basically, Josh, give us some of your perspective on some of the things that you're running for Senate up in the
District 7, yes, the newly created District 7.
And that's Mr. Forsyth, Senator Forsyth's old seat.
That's correct, yes.
Right.
Yep.
By the way, just you got an endorsement recently from Senator Forsyth.
Yes, Senator Forsyth is behind me, and I'm very grateful for that. He is a highly respected, well-respected proponent of limited government, and we stand for many of the same ideals, and I'm proud to have his endorsement.
Great. Well, there's no coincidence that we have Mr. Miller and you on at the same time. You know, I've met you up at the Capitol on a number of occasions. And,
Sure.
And yesterday we had a hearing.
Yes.
And you graced us with your presence at the hearing. We could see you in the background with your interest in the Haas case. And that case was founded.
Yes, it was, overwhelmingly.
Mr. Nick Haas and Representative John Burt was his sponsor. We want to thank some of these sponsors, by the way. Without them, this doesn't go any further.
That's correct.
They pretty much vet the cases before they even come to us.
They invest a lot of their personal time, and
Right.
they're actually taking on a bill. It's sponsoring a bill, so to speak.
Right.
And it's very, very difficult. It's time-consuming. There's a lot of investigation. There's a lot of reading. There's a lot of meeting time, and of course, they're all volunteers. And so we thank all of these sponsors for doing such a wonderful thing.
And just to let you know, what happens is with this newly created committee, we have a state representative that will hear a case. They'll think that there's some credibility to it. They do a little investigation. They'll go to some of the court hearings on some of these matters or wherever there's a situation. Then it goes before the Rules Committee before it gets any further. The Rules Committee says, yeah, there's something here. We'll let it go before the Redress Committee. Then it goes before the Redress Committee. I don't know how many times Mr. Haas was before us, but there were hours and hours of testimony and documentation in order to say, you know what, this is credible, this isn't credible. And so to draw off that and to let people know that these aren't people that just come in, they're not just mad dads or mad parents or angry litigants.
Well, there are a lot of female
Yes.
petitioners as well.
Right.
And so I don't believe this is necessarily just a dad situation. This is a parent's problem.
We want
this
to
is
dispel
a family problem.
Correct. I guess I brought that up because of the vetting process is so extensive. We've actually documented it on Speak Up on a couple of cases, and yours was one of them. What are some of the highlights of yesterday's that you see endemic or systemic with our family courts? Just with the Haas cases, what did you see was a flagrant issue that you thought?
Well, as you know, Kevin, I followed a lot of the petitions, and I try to appear at as many petition hearings as possible. And one thing that I'm noticing, and I speak with the petitioners, and I know the petitioners, and I've read their case files, and I see the evidence that they have. And something that's particularly troubling to me is that there seems to be widespread denials of due process. And I'm not sure what's causing it, but it's happening. Mm-hmm. When I am presented with a court order from a petitioner, and the court order says what it says, and then I pull up a statute or a provision from either a federal or state constitution, and the court order does not comply with applicable law, that is a very serious problem. And of course, we're human, so it's expected that there's no system that's perfect. But we have to live inside of the margins. And inside of the margins, we're seeing many, many, many situations where the court is denying due process, substantive and procedural due process. With the Haas case specifically, Mr. Haas was jailed based on an arrearage that he was ordered to pay on child support. Well, in fact, the arrearage was ordered ex post facto, which means it was ordered after the fact.
Right.
It is a well-settled principle of American jurisprudence that states that no ex post facto law shall be enacted, which means you can't just look back and make a law that occurs sometime in the past. So Mr. Haas was faced with incarceration. The short story is he was faced with incarceration. He was transported to the Valley Street Jail, and he was presented with a piece of paper, which read financial affidavit at the top.
Which the court had already looked at.
Correct.
And said, you know, that's not good enough.
Correct.
So we're going to send you to jail in a civil contempt.
In civil contempt.
And in jail, tell us the rest of the story.
What happened was he was presented with a blank financial affidavit form. And unfortunately, Mr. Haas was not given the luxury of having his entire filing cabinet that he might have at his house or his office next to him to reference so that he can accurately fill out a financial affidavit. And so for the viewers that may not be familiar with this, an affidavit is a sworn statement made under the penalties and pains of perjury. If you fill it out incorrectly, it's a criminal offense. So Mr. Haas was forced to fill out an affidavit and swear to the veracity of that statement without the ability to go to the sources and resources
Right.
to pull the data to put onto the form.
So the court says you're going to sign right here.
And if you don't, you're not getting out of jail.
Mr. Miller, thank you again for joining us. I can only picture Mr. Haas being in that cage, being in that jail cell, and the judge saying, we didn't like what you said. We don't like your financial affidavit. We're going to give you an opportunity to get this right without having the forms there. In the meantime, he's separated from his children. The amount of emotions that goes through a parent's mind when you are separated from your child and you're sitting in the cell, in your case, without actually talking about your case, you've gone through hell and back. You've spent a fortune because you love your children.
That's absolutely right.
Tell us a little bit about the emotional traumas that you've gone through in your case, if you don't mind. Just take us where you want to go with this, but what are some of the emotional things that you have to go through as a dad, as a parent?
That is such a hard question to answer because your emotions, you're on a roller coaster the minute your children are taken away. You're on a roller coaster. You have in this back of your mind, I'll see them soon because, well, this is America and this is our courts and we have the best courts in the country and we believe in fairness. Days turns into weeks and weeks turn into months and months turn into years. I believe I said this on your last segment that I didn't recognize my children when I saw them again. They could have been anybody's two children. I wouldn't have known them. That's outrageous. In the time that they were separated, I missed birthdays, I missed holidays, Thanksgiving, I wasn't there for them or with them. Their Christmas, I didn't have Christmas with them all those years. I wasn't there to take them to school the first time and on that first day and show them their classroom and get them seated and make sure everything was good. And I wasn't there to hear them come home and hear the chatter about this is what happened at school today and I met little Susie and she's just so cool. I missed all of that. In the time that I was separated from my children, I wasn't a soccer dad and I wasn't there to be part of their lives in any way, shape, or manner. I wasn't there to have any influence over how they were raised. Not because I had done something wrong, but because somebody had made a malicious accusation to try and benefit themselves. Probably the hardest part of those 2.5 years was watching other dads with their children. And then you reach down and that little hand isn't there. You know, that's tough. That you can't, it affects your life in every aspect. It affects your job. It affects your relationship with other people. It affects family. You become irritable constantly. And I've been criticized because I've got angry and because I was irritable. I wonder how that person who criticized me would feel if their child had been taken away when they had done nothing. Remember, I was determined to be guilty the minute they walked away with my children, without any hearing, without any evidentiary hearing or anything else. They just take the children away and say, you must be guilty because, well, there's an accusation there.
Almost like the Salem witchcraft, or witch hunts. They throw out an accusation, do a little dance, and you know, all of a sudden you're being hung.
Try to prove a negative. Try to prove something didn't happen. It's almost impossible. I subjected myself to polygraphs, to countless interviews. When my case started, I lived in Michigan. I was back and forth to New Hampshire on a weekly basis. The cost was just staggering. I ended up going bankrupt. It ruined my life in every way, shape, and manner. It destroyed my career. Probably the saddest in my particular case was that during this time where I was prohibited from having contact with my children, my father died without getting to know his grandchildren. My brother died without getting to know his nieces. You can't undo that. That can't be undone. And the court, and I truly believe this, they think, well, we'll give Dad, now that it's been proven that he didn't do anything, we'll give Dad every other weekend and that should be good. It's not good. No, because it ignores how this all came about and where the problem really started. So even though I never did anything to my children, even though I never harmed them, that I'd give my life for them in a moment, people look at me as if I had done something wrong. And I see this a lot, that look of suspicion where you got away with something. I saw that out of the judge's eyes. I saw that out of the guardian ad litem's eyes. I mean, I even saw one paper where the guardian ad litem said, well, he's just getting away with it. We'll catch him. It just, that's disturbing. The emotional damage, you can't understand, and I can't express it adequately.
Josh, what's the solution?
Well, what Mr. Miller's been talking about is just disturbing me, just even sitting here. And I had a couple of comments that just are buzzing through my mind. This is just incredible what's happening, and I can 100% appreciate and actually feel what you've endured. But this whole concept of being accused and having something, evidence, hidden from you speaks right back to the Article 15 problem that Mr. Haas was having.
Right.
How can you possibly challenge or impeach evidence when you can't obtain the evidence? And that's a very serious problem. The other problem is it shakes the very foundation of the principles that the state and this country were built on, that you're innocent until you're proven guilty. Unless there is a strong countervailing threat, meaning imminent harm, imminent danger to the children, then Mr. Miller is innocent, period.
Exactly. Right.
And, you know, the New Hampshire Supreme Court very recently, 6 months ago, in a case called In Re Guardianship of Rena D., stated that a fit parent will continue to have the status of fit parent until he or she is adjudicated unfit.
Right.
Which means you're innocent until you're proven guilty.
Were you ever adjudicated as an unfit parent at any point?
Never.
Were you ever adjudicated?
Never. Now, there's an interesting, that segues into a very, very important piece of law. It's called Troxel versus Granville. It's a U.S. Supreme Court case, and one of the most important statements or doctrines that comes from Troxel is there is a presumption that fit parents will act in the best interests of their children. So we have an innocent person who's not been adjudicated unfit, who, according to the U.S. Supreme Court, is presumed to act in the best interest of his children. I ask rhetorically, actually I don't ask it rhetorically, I ask it factually and actually, why were the children removed? There's no legal basis.
Right.
None.
You know, if you told me 20 minutes ago I would try and take this side of the argument, I would have said you were out of your mind. But the fact of the matter is, on trying to look at it through the court's eyes, they don't really know what happened. All right, they really don't have a clue. We have a parent making an accusation. We're having a parent say, "I didn't do this." Okay, and you've got the children stuck in the middle. The court almost has, based on the severity of the accusation, they really almost have their hands tied to say, we have to do something here. We have to protect the children. But there's ways to do it other than completely removing the child from the parent's life, which is what happened in
It's
my
kind of like
case.
cutting the baby in
That's
half,
right.
really.
That
basically.
you could definitely give supervised visitation. You could certainly say the investigation needs to be done in 30
Expedited.
days, 45 days, something like that. There's a lot of safeguards you could take. In my particular case, as soon as one accusation was determined to be unfounded, in order to extend the time that I was kept away from the children, another accusation would be made right on its heels before we could even get back into court. What's disturbing is that DCYF was willing to entertain one false accusation after another false accusation after another false accusation. The court was too willing to sit back and say, well, we've got these accusations and you don't know, maybe the first 5 weren't true, but who knows, maybe when we get to accusation number 17 or 18, maybe we'll finally get one that we can make it stick somehow. And it almost seems, excuse me, but it almost seems as if there is an underlying desire, and I don't mean to sound paranoid, but an underlying desire that somehow we got to get one of these to stick. In my particular case...
But what would be their incentive if there's compelling evidence proving, if you will, innocence? Is there money tied to this? I mean, what's going on?
We don't know.
I don't know.
We don't have any idea.
I don't know. In my particular case, probably what makes it so heinous is that the court, my case actually started in Michigan, all right? And the accusation was made there by the mother and the grandmother, okay? And it was determined to be unfounded in Michigan. We brought the case to New Hampshire, and that very issue was tried again, right at the very beginning, okay? And it was determined by the court that it was not only that it was unfounded, but it was done for
Malicious?
a nefarious, a malicious purpose, okay? And it seems like when the next accusation came, we forgot this person was willing to do this, that they were willing to make these type of accusations. It seems to me when the first one came back unfounded, all right, we're going to get Dad back with the kids, and that second one comes, we're going to look at it with a jaundiced eye. We're going to look at it very carefully here because something's wrong. And we're not just going to interfere with a parent's fundamental liberty right to raise his child because another accusation has been made. Even if, to go on a sidebar, even the IRS can only come to your door so many times, interview you before they have to back off. DCYF doesn't have that. They can just keep coming and coming and coming as much as they want. And with each one that comes, sooner or later, you're going to get some person out there who's going to try and say, yeah, you know what, maybe this time. Or worse, you know what, I have no idea what's going on. Let's throw this over the wall to the prosecutor. Let's put this in front of a jury and see what happens.
And what we've seen is whenever an innocent litigant or a fit parent pushes back, they become classified.
Right.
It's almost as though there's a column. There are columns. There are the easy litigants, there's the pushovers, and then there's the despised litigant.
And woe unto you if you're a despised litigant and you're pro se.
I mean, it's over. It's over. And unfortunately, this leads us into a whole set of other problems, which I don't even know if we want to get into, is the right of appeal. I mean, there's virtually no way to get any justice if the trial court makes a mistake.
I think before you get there, though, there's just one comment I want to interject in that. You fight for your innocence to prove that you didn't do it, and you hear people saying, you know what? he's fighting so hard to prove he didn't do it.
He must be guilty.
He must be guilty.
He must be guilty.
Yeah.
I heard that out of professionals that were charging $250 an hour come back and say, you know what? Every story she comes up with, you're able to prove it's a lie. Seems to me you're fighting. You two are fighting so hard. You're a bad person for trying to prove your innocence. And that was said in my case. You're a bad person because you're trying to prove your innocence. You're fighting with her. But the alternative is if I don't fight back, if I don't show that I didn't do it, I very well could have had my case flipped over to the prosecutor and been prosecuted. So where do you win as a father? Where do you win as the parent? And let me strike that. Not the father, but where do you win as the parent who's had your child taken away?
Your fortune's taken away in that your children. That's your fortune. Your work, your psych, everything about your life has come to a complete halt. And I just don't understand why people have not flipped out.
In the cases that we've studied, it appears that the family court uses a one-size-fits-all solution.
Right.
And unfortunately, that goes against the very statement of purpose of the family division.
As a senator, how will you fix this? I know 415, we took it off the table. I was one of them that fought for 415. It was tabled in Child and Family Law.
Which is the sealed envelopes bill.
The sealed envelopes. We went there. Representative J.R. Hole said, hey, Mr. Avard, we got to fight this. We got to get this off the table. And then he said, well, you sit on redress. And then it all came together with the Johnson case. And I said, because of a sealed envelope. We got it off the table. The House voted to pass 415.
That's right.
It went to the Senate. I don't know what happened there, but that's a whole different beast.
Well, it turned into a different bill, basically. It took on an entirely new identity.
It was essentially rewritten, where the bill, and I know this because I helped author that bill, it was meant to give the accused parent greater access into these documents of DCYF. When it was rewritten by the Constitutional Law Committee, from my understanding, that it actually was rewritten and took powers away from dad. Dad lost, or mom, the accused parent, I'm sorry, lost more rights than what they had nothing taken place. And the question becomes, how is that happening? Why are we doing this? You know, I heard that we have to protect the children. It seems like that's the battle cry of the other side. We have to protect the children. But we're talking about the children has been taken away from the parent. Okay?
But in the Senate, I'm wondering, what happens here? Are these people so lobbied by what does DCYF stand for anyway? It's Division
Department of Youth, Children, and Families.
Are they so lobbied by them that they can't see? And why did the Senate break down and change the language, which is supposed to protect the parents?
In my opinion, and I don't know of the inner workings of the Senate because I wasn't a senator, and I'm not yet a senator. I hope to be. However, I can tell you that everybody wants what's in the best interest of children. I mean, I'd say the majority of society really cares for children in their hearts. The problem is what they believe the best interests of a child is.
Is it the state or is it the parent?
Exactly. And what's happening is lawmakers and the people within the Department of Youth, Children, and Families have an ideology, a culture of what they believe is the best interest of the children. They're ignoring well-settled law that says parents are the ones that are best poised to determine what's in the best interest of the children. And until a parent is not a fit parent, they should retain control. In my opinion, excuse me, the state is stepping in far too early. I'm not saying the state doesn't have a place in protecting children, because there are plenty of children that legitimately need protection against abuse and neglect.
Yes,
I think we can all agree on that. I think where the fundamental disagreement is where we're drawing the line. And I am saying that from a constitutional and from a legal perspective, the line in the sand needs to be drawn more in favor of the parent, because it is well settled, and I'm going to say it again because I can't say it enough times, that fit parents are presumed to act in the best interests of children. We need to wait until there is a strong tendency to believe that the parent is going to not act in the best interest of children.
Right.
And just because we have a divorce proceeding or a custody proceeding, that doesn't mean that the parents are bad people. It just means that the parents aren't getting along. So we need to really define where the state's going to get involved. Myself personally, I believe the state needs to back off.
But what type of legislation would you introduce in order for them to back off?
Well, I would really codify some of the Supreme Court decisions in statute, because you mentioned Rule 1.2, which says, for good cause shown, any one of these rules may be waived.
Or 3.9?
3.9 is a different application, but that's another rule that we have some serious problems with. But here's the thing: is a judge cannot waive a statute. They can waive a rule. They don't have to follow with what's called stare decisis, which is the lineage of Supreme Court cases and higher authority cases from higher courts.
I know in the Vandenberg case, they waived, that Judge Arnold waived an order.
Yes. Well, because what he probably did was he vacated his own order, and he just rewrote the order. But one thing a court cannot do is waive a statute.
Okay.
So we need to codify, we need to create statutes that give some of these well-settled principles of law some teeth. We need to make it so courts cannot just willy-nilly exercise discretion before a certain point. Because there are far too many people that are suffering, innocent people that are suffering unnecessarily, not the least of which, actually the foremost of which, are the children.
What are your thoughts?
I think reform is necessary. I think the statutes need to be tightened up. We did mention 415. I was part of drafting 415. There's another one out there that I drafted I believe it's 506, which says in cases where false accusations are made like this, if they're done maliciously, a parent can't have primary residential responsibility. It was drafted more to be as a weapon, a threat, and hope for deterrence than to actually be implemented.
But if there's clear and convincing evidence that there's some abuse going on, we don't want to discourage that.
Absolutely not.
Right.
But this isn't, 506 wasn't about where the abuse actually took place. It's when we found out that the abuse didn't take place, that it was done to gain a tactical advantage. And it is a huge tactical advantage. If you can get the child taken away from the other parent in a courtroom, that is a huge tactical advantage. But you can't reward a litigant for using the system that way. Matter of fact, and as you said, there needs to be teeth. There has to be some penalty for doing that, not just, okay, well, we'll pretend like that didn't happen. In my case particularly, one of the judges who sat in on one hearing said, well, we know all about the false accusations and all that happened, but we're going to pretend like nothing happened. Nothing matters except from here going forward. That's disturbing, right? Because the best predictor of what's going to happen in the future is what happened in the past. And I guess, and I wanted to touch upon this, and I'm going to go on a little of a tangent, so forgive me here, but whether the parent did it intentionally or unintentionally, in cases such as mine, where it's happening repeatedly, okay, that's not in the child's best interest that it be allowed to continue. Custody needs to change at that point from the parent who's making these, even if they're doing it because of a mental defect, because they're trying to leverage an advantage or whatever. If it's happening over and over and over again, the ultimate person suffering is the child, and something needs to happen. And I know there's this pervasive attitude that once you've established the child in one home or the other home, you leave them there. There's something good to be said about it, but that principle's been abused by the courts. If in that home the child is being told that something bad happened to you and your dad did it, or or whatever to interfere. We're not going to let you go see your dad today, or we're not going to let you go see your mom today. Then the courts have got to be willing to step up to the plate and say that behavior is just unacceptable. And that will be the reason to change custody. If you read through the opinion in my case, the Supreme Court came out and they articulated that from various decisions around the country where there is a presumption that the parent with the residential responsibility is going to act in the best interest of the child. And when they fail to live up to that, for the child's sake, you've got to change custody. And I do understand, stability in the child's life is good for the child. But at some point, there's got to be a weighing test, a balancing test here of when does leaving the child in an abusive or, and I hate using that word, but abusive, but I don't have another word, leaving in an abusive home versus the upset and the turmoil of changing their home, when does one outweigh to the other? And that's really what the judge's function is
Right.
that when, okay, this is one of those times where we need to change it. You don't want to do it lightly, but you don't want to keep putting it off and hoping and hoping and hoping someday that the aggressive parent is going to change their behavior. They're not going to.
So in some of these cases, though, we're not dealing with judges. We're dealing with marital masters, which are not judges.
That's right.
I'm not so sure if that is part of the problem.
Well, RSA 461A2, I believe it is the state's statement of purpose, says that children do best when they have both parents having a stable, meaningful relationship, which includes having frequent and regular visitation with children. Now, when you link that up with RSA 490D2, I believe it is, which is the implementation of the judicial branch family division, they talk about what the purpose is of the family division. It's to provide...
Meaning the courts.
That's correct.
Okay.
The family division of the courts. Now it's called the Circuit Court Family Division. Now, the purpose of the family division is, in part, and I'm quoting loosely, to utilize judges and judicial officials who are specially trained to handle marital matters.
Oh, like guardian ad litems.
Well, guardians ad litem.
I'm being facetious.
Yeah, marital masters. Right. And I made earlier the comment that there appears through across the cases that we've been studying that the courts are using a one-size-fits-all solution.
Right.
Allegation, remove the children, extended period of disunification, plan for reunification. Of course, all of this costs a ton of money. Now, Mr. Miller mentions maybe it was you that mentioned the guardian ad litem, the marital master.
I did. Yeah.
I believe personally that the marital master, being a hearing officer who is an at-will employee of the judiciary, they're not appointed by the governor and approved by the executive council. They're literally attorneys that go to a training seminar to become quote-unquote experts on family law. But we're not finding that they're experts. We're finding that there are many components to family law that are outside of family law, such as contract law.
Right.
You need to be very well versed in contract law because you're splitting up assets in many cases.
And you're forcing people to sign a guardian ad litem contract.
Correct.
Yeah.
You're dividing property. You're allocating mutual funds and real estate. You're appointing guardians ad litem, which segues us, and I don't want to go on too much of a tangent, but I'll spend just a second on this. A guardian ad litem is what's called a friend of the court, or an amicus curiae. They're somebody that helps the court. They have a particular expertise and I put that in quotations, they are supposed to have an expertise
right.
in a particular discipline. And unfortunately, that is a system that has been a runaway freight train. They're necessary in many, many cases. But unfortunately, the court has come to rely on guardians ad litem more so than they rely on the discretion and the function of the judge himself or
Which
herself.
is incredible, the amount of power that one of these guardian ad litems can do to one individual, to an entire family.
Correct. But now this is the interesting twist to throw a little bit of contract law into this. They are appointed by the court. which means they enjoy absolute quasi-judicial immunity. They can never be challenged for any reason civilly, period, end of story. They have as much protection as a judge.
More than police.
Absolutely. Police only have qualified limited immunity. So they need to prove that they were acting in the function of their duty. You know, if a police officer were to shoot someone, and his defense would be like, well, my life was being threatened, or another citizen's life was threatened, in which case he would enjoy immunity. Guardians ad litem have the same exact level of absolute protection as a judge. But here's the twist, the big problem. The big problem is that there's a contract law twist to this. A guardian ad litem must be appointed by a stipulation. The court says, okay, Joey or Sally guardian ad litem, you are now the guardian ad litem of record in this case. You're the amicus curiae, so to speak. You're the one who's going to gather the information and do all this great work. But in order for you to be appointed, parent A, mom, and parent B, dad, has to sign this thing called a stipulation. And a stipulation is called an inter partes contract. Basically, it means that there are two or more people that must sign it in order for it to happen. In many cases, it is a mother, a father, the guardian ad litem themselves, the court, if there are interveners involved. An intervener is another person with an interest in the case, such as a grandparent or somebody else that has a compelling interest in the litigation. So I asked the question, what happens if somebody doesn't sign the guardian ad litem stipulation? Can the court appoint a guardian ad litem? Well, that brings a whole discussion into play about contract law. And we found in studying these cases that marital masters specifically, and many judges, either have no idea what to do, no clue because they don't have training in contract law, or the judges are in checkmate. They're in gridlock. What do we do? Mom refuses to sign the guardian ad litem stipulation because she doesn't like the terms. She asked the guardian ad litem to change the terms. The guardian says, no way, this is how we do business. Okay, fine, I'm not signing it. What happens?
We dangle the kid. You are going to sign this contract,
or else.
Or you're not going to see your child.
This creates, and I don't want to go on too many legal tangents, but this is important stuff. I mean, this is human stuff. I know I'm not sounding human in this so much, although it's very important to read into the legal components.
It affects everybody.
It affects everybody. People need to be educated and become aware of what's going on in the legal community around them. This is like water dropping on the floor. It goes into every single crack. It goes under the door. It touches all of us. Right. And the problem is that when you sign a contract under duress, it's called threat, duress, or coercion, under the UCC Article 1, Section 308, it says that that contract is null and void, period. Has no force, no effect. It is as though, in legal contemplation, it is as though it was never signed.
And we'll be right back on a little break. I want to thank Mr. Youssef and Mr. Miller for joining us on the show. We're going to take a little break and wrap this up.
Thank you, Kevin.
Well, we're back with Speak Up, and we're going to wrap this show up. I want to thank Josh Youssef and, of course, Mr. Miller, Jim Miller, for joining us on the show. And it's just some final thoughts, basically. We were talking on the break about how long these cases go, and in a couple of minutes, what are your final thoughts on the extensive length of these cases?
My case, 8 years, and I know I've heard over and over cases that last 2, 3, 4, 5 years, and that is becoming more, it seems, the norm the more people I talk to. In a lot of states, you have 12 months from the day of filing, the judge does, to get the case wrapped up. Okay, for good cause shown and with approval of an administrative judge, they can extend it for another 6 months or 12 months. Okay,
for the exceptional case.
For the exceptional case. But you can't, a marital master, a judge, cannot allow a case to go 5, 6, 7 years and then look mom and dad in the eye and say, I'm interested in the best interest of the children, because if you were, you'd get the thing wrapped up and get it over with.
I think in the Haas case, there were a couple of marital masters involved with that one.
Yes.
And that's just nuts.
Yes.
It's nuts. Well, gentlemen, I want to thank you very much for coming on the show. We're definitely going to ask you to come back and give us an update, and maybe talk about some more specifics with situations with the family courts and the like. So I want to thank you very much for coming on.
Thanks for having us.
All right.
Thank you very much.
All right.
Thank you, Kevin.
All right. Well, thank you very much for watching Speak Up. If you enjoy the show, if you find it informative, we would love you to be a sponsor or get in touch with us. You can either email us at speakupnh@gmail.com or write me, Kevin Avard, speakupnh@68 Bartimus Trail, Nashua, New Hampshire, 03063. Until next week. Every day, citizens around the country are faced with new dilemmas. Dilemmas that affect them profoundly. Whether it's injustice, discrimination, falling through the cracks, scandals and cronyism, balances of power, ethics, religious freedoms, state versus citizens, and unfunded mandates, and the list goes on and on and on. Welcome to Speak Up. It's directed at those who have fallen through the cracks, and it gives them a voice. It's your turn to speak up. To stand up and fight back.